Well, hello to everyone and welcome back to the next edition of Outline following our summer break. I hope you managed to get some relaxation over the summer, whether you were brave enough to venture overseas or stayed a little closer to home. I hope you had some time off. My name is Trevor Ivory. I am the UK Head of Planning at DLA Piper, and I'm joined today by two of my colleagues. Firstly, one of the stars of the planning team, our Legal Director, Ian Graves, and also one of my partners, Howard Basford, who is one of the country's leading infrastructure planning lawyers. So good, welcome to you, Ian and Howard. Now, before I begin, I ought to say most of these sessions up to now, most outline episodes, we've taken part from home. I want to reassure you, we haven't spent the summer decorating all our houses in some sort of corporate colour that looks exactly the same. We are, in fact, excitingly all in the office today, albeit we're still in separate meeting rooms in order to maintain distancing. So please rest assured, we haven't gone DLA corporate colouring in our home decor choices. Now, today we're going to focus on heritage and particularly the impact, the approach to the assessment of impacts on heritage assets in the planning system. This has been a significant source, I would say probably one of the most fertile sources of challenges to planning decisions of the last few years, certainly since the Barnwell Manor litigation in 2013 and 2014. But I think it's probably fair to say that few and probably no case has attracted quite as much attention or dealt with quite such significant and sensitive heritage assets as the decision of the High Court at the end of July to quash the Secretary of State's decision to grant development consent for a proposal on the A303 at Stonehenge. That was a judgment that was issued following a 3-day hearing before Mr. Justice Holgate in June. The claimant was a campaign group, the Save Stonehenge World Heritage Site group. The challenge, as I say, was to the Secretary of State for Transport's decision. And it's notable that there were two other interested parties who took part in the hearing, Highways England, who had promoted the DCO, and Historic England, who obviously were heavily involved as a key consultee. But perhaps before we get into the detail of the case, we could set the scene. And Howard, if I could perhaps bring you in to start with, Stonehenge, probably one of the most iconic heritage assets in the world, perhaps a World Heritage Site in its own right, but it is about an awful lot more than just the henge that immediately springs to mind when you hear the word, isn't it? There's a lot more going on there in heritage terms.
Yes, it's important to realise two aspects of the Stonehenge case which give it longevity. This is the latest chapter in what has been going on for many years and which will doubtless continue to run for many years to come. Stonehenge is not just the iconic circle of stones which are famous worldwide and grace many a television program or an advertisement for visiting Britain. The World Heritage Site that embraces the standing stones, the henge itself, spreads over many, many square kilometres, as often World Heritage Sites do. And it embraces assets which reflect the way that early civilization developed around the henge, that people interacted with it and its cultural significance. And these assets go right back to the very cradle of civilization in these islands, and they're critically important for that reason. That's the importance of the standing stones and the environment and the landscape that are around it. And it's why it is something which is addressed with very great care in planning terms. At the same time, the henge is on a historic route from the southeast of England to the southwest. And that route is very ancient as well. And ultimately, it has become the A303 trunk road, which is the responsibility of Highways England as the strategic highway authority for the United Kingdom. As well as being a strategic route, it is also a bottleneck. And when we see those television pictures of Stonehenge, they're usually carefully cropped or curated or from a particular distance, which doesn't show quite how close the A303 with a steady stream of vehicles is to the standing stones. And those vehicles, of course, whilst they represent its long-term position on this important route, also detract from its ancient status. And those vehicles represent an impediment to economic development, to the free movement of goods and people in the country. And there is inevitably a trade-off then between the infrastructure needs of the A303 and the World Heritage Site and the many listed and scheduled assets within it. With this, Trevor.
Sorry, Howard, I was just going to say that you might start by saying that you're rather brave to have a go at promoting anything anywhere within such a sensitive site, but that really is the reason, isn't it, as to why Highways England were looking to promote this scheme, was to try to resolve that existing conflict between the A303, the World Heritage Site and the other assets, and also that economic need to remove the bottleneck, I think.
That's absolutely right. And the A303 upgrade in the vicinity of Stonehenge has been a part of the government's roads investment strategy. It is something to which Highways England has been committed. And there have been a number of attempts to resolve this down the years, the latest scheme subject to this litigation being only the most recent. And of course, it is responsible to take steps to mitigate the impacts on the World Heritage Site, to improve that environment and also to improve the environment for the travelling public. And that tension is what the application that Highways England as the Strategic Highway Authority sought to address in its application. The application, of course, was for a development consent order under the Planning Act 2008. And that is the means by which a really significant project of this status should be promoted.
So let's just sort of finish setting the scene by turning to the law and policy, if we can. Ian, perhaps could you sort of just summarize for us the statutory and the policy framework surrounding the assessment of impacts on heritage assets within the general planning system?
Yeah, thanks, Trevor. So, I mean, there are sort of two main ways that that heritage is protected. So there are statutory provisions, and then there's sort of strong protection in planning policy. I mean, obviously, the point here really is that you know, there's no sort of general preclusion on development that affects heritage assets. But what we're really trying to do through law and policy is to strike the appropriate balance. So there is that strong protection for heritage assets, but at the same time, allowing development in an appropriate way. So what we effectively have in the general planning system is two statutory duties on local planning authorities when they're considering development that affects heritage assets. So we've got Section 66 of the Listed Buildings Act, and we've got Section 72 of the Listed Buildings Act. So Section 66 it requires a local authority, when it's considering whether to grant planning permission for development that affects a listed building or the setting of the listed building, to have special regard to the desirability of preserving them. And Section 72 is a sort of similar duty that relates to conservation areas, although that requires special attention to be paid to the desirability of preserving or enhancing the character or appearance of the area. So they're two statutory duties that apply to local planning authorities when they're making decisions on planning applications in the general planning system. Allied to that, there is the National Planning Policy Framework, tests in paragraphs 194 to 208. And what this effectively does is it sets out a sort of a matrix of tests and policy guidance that local planning authorities need to consider and apply. So what the National Planning Policy Framework directs local planning authorities to do is to require an assessment of the significance of the relevant heritage asset. And it should be said that heritage assets in this sort of context aren't restricted just to listed buildings or conservation areas or those sort of assets with statutory protection, but also include other sort of non-listed buildings. So, you know, you have locally listed buildings or whatever it is, but also would include things like the World Heritage Site, for example, at Stonehenge in this case. So the National Planning Policy Framework effectively goes a little bit further than the statutory duties that we've just that I've just recited. So as well as requiring planning authorities to have particular regard to the heritage assets, it also specifies that great weight should be given to their conservation. And the greater the significance of the asset, the greater the weight should be given to its preservation. And what the National Planning Policy Framework then goes on to do is require the planning authority to assess if there is harm to the significance of the asset, to assess the degree of that harm. So there is then a sort of a twofold test, and in the Stonehenge judgment we'll come along to talk about in a second, this is described as the sort of fork in the road test. But effectively what the planning authority must do is, if it concludes that there is substantial harm to the relevant asset, that means generally that the application should be refused unless the harm is outweighed by substantial public benefits. On the other hand, if the planning authority concludes that there's harm, but the harm is less than substantial, then that means that the harm must be outweighed just by public benefits. So there is a difference in the way that the council will carry out that balance, depending on the degree of harm that it concludes is present. And as you say, you know, there have been lots of challenges in recent years based on sort of heritage grounds. So the Barnwell Manor case that you just referred to there, that was a case in which it was concluded that the decision maker had not complied with the Section 66 duty that I referenced earlier on. And there've been a line of cases since then, including a case called Mordue, in which the court held that, you know, in general terms, if a decision maker goes through and applies the tests in the National Planning Policy Framework, generally that will be sufficient to discharge that Section 66 duty.
And Ian, it's probably worth also mentioning in the context of Stonehenge that the other statutory duty that applies, I think, is under the Ancient Monuments Act, isn't it, which specifically protects scheduled ancient monuments in a similar way, and clearly with Stonehenge, that was another relevant protection, wasn't it?
Well, quite, and of course, you know, the World Heritage Site itself is protected by an international convention. But yeah, you know, you're quite right. The Scheduled Ancient Monuments Act of 1979 applies that protection to scheduled monuments. Yeah.
So that's under sort of general planning, the 1990 Act approach to planning. But Howard, as you pointed out, this was a DCO application, so it was made under a different regime. It was the 2008 Planning Act. What's the position in terms of the approach to heritage there? Is it similar, or is it significantly different from that regime that Ian's just explained?
So the Planning Act 2008 was designed to streamline planning applications, to provide a one-stop shop for critical pieces of national infrastructure. And so the approach that's been taken there is very much to assemble the tests into a single place rather than to dilute them. And so it's not very surprising that the tests are the same in the Planning Act 2008 position. So the way that works is as follows. If you have a nationally significant infrastructure project, which is to be consented under the Planning Act 2008, then where there is a national policy statement in force, in this case, the National Networks National Policy Statement, the NPSNN, then the Act requires the decision to be taken in accordance with Section 104. And Section 104 says that you have to determine the application in accordance with the National Policy Statement, unless certain other things apply. One of those things is where the harm of the project would outweigh its benefits. So that is the situation under the Act. The National Policy Statement for National Networks, the NPSNN, is then the critical document. It has a great deal of force in how things are addressed, because it describes, for instance, the way that decisions must be taken. And in particular, one looks at paragraphs 131 and 133, 5.131 and 5.133 of the NPS. And 5.131 is the section in the NPS which tells you about how you determine whether there is substantial harm or less than substantial harm for different types of asset. And of course, the more important the asset, the greater the risk that the harm will be substantial. And in those circumstances, if it's a very important asset, then for the harm to be justified, it must be wholly exceptional. And then paragraph 5.133 operates to require a refusal of an application in circumstances where there is substantial harm or total loss of significance, unless there are substantial public benefits which outweigh the harm. And so it maps very closely the decision-making requirements for the general planning system. And that's as one would expect, because one wouldn't expect a nationally significant infrastructure project to be treated with any less rigor than an ordinary general planning application.
And I think for me, the similarity between the two systems means that this case and some of the consequences of it are relevant not just to the NSIT regime and DCO applications, but also are relevant to general planning. And I thought a good example of that in the judgment was that Mr. Justice Holgate was wrestling with the Court of Appeal's decision in the Bramsville case earlier this year, which we discussed on an earlier edition of Outline, and that was very much a 1990 Act case looking at a decision to grant planning permission. And just as a quick reminder, what the Court of Appeal said there was that a decision maker where there are heritage impacts that are possible from a proposal, they have to undertake a three-stage evaluation. They need to firstly consider the significance of each heritage asset that may be affected. They then need to look at the impact of the proposal on each asset's significance. And having done that, they need then to conclude on the weight to attach to each of the impacts that they've identified. But the critical point for the Court of Appeal at the heart of that case was that whilst those three stages of the evaluation are non-negotiable, they have to be done. How a decision maker approaches that evaluation is not prescribed. There is no prescription around it. Ultimately, the decision maker will need to decide how to do that in any particular case. And I think Ian, the judge came back to that case on a number of different issues, but one of the more interesting areas where he was looking at Bramshill and looking at the consequence of that for the Stonehenge case, was looking at the implications of Bramshill in a situation where you've got a proposal like Stonehenge, which is dealing with so many different heritage assets and different designations overlaid on top of each other, I think.
Yeah, I think that's right. I mean, you know, plainly in this case, there's a very large number of heritage assets on the site that needed to be considered by the decision maker. So, you know, there were 11 non-designated heritage assets, 14 scheduled monuments, and of course the settings of those assets as well needed to be taken into account. So this is as well as the henge itself and the World Heritage Site more generally. And what the claimant in the Stonehenge case was arguing essentially is that the Secretary of State in his decision hadn't considered the impact of the scheme in relation to each of those heritage assets individually. So it was said, I think, that he carried out a sort of a composite assessment. So he'd sort of lumped everything together and come to a general conclusion in respect of heritage impact. And in fact, that he'd applied a sort of a blanket discount to the level of harm. So he'd taken the heritage benefits and he'd used that sort of generally to reduce the level of harm that he concluded was there in relation to heritage assets. And as you say, I mean, that point really, I think, was based on the Court of Appeal's decision in the Bramshill case. Because as you say, you know, in that case, what the court said is that, you know, every element of harm and benefit to each of the heritage assets has got to be given its sort of due weight. And you know, generally this would be easier in a sort of a run-of-the-mill Planning Act case. It is sort of fairly unusual for there to be more than a small number of heritage assets, or or even one heritage asset. But obviously, particularly in sort of very big projects, linear infrastructure projects like this, there can be many heritage assets that need to be considered. So I mean, in this particular case, it was clear that the Secretary of State's decision didn't assess the impact on each of these individual heritage assets. And what the court said, having sort of taken into account the Secretary of State's decision letter, and also the sort of witness evidence in the case from officials as to what was before the Secretary of State when that decision was made, was that effectively that the Secretary of State couldn't rely on the assessment of each of the individual assets that had been undertaken in the environmental statement, because that wasn't before the Secretary of State when the decision was made. And in fact, the sort of summary of the environmental statement that was given to the Secretary of State didn't adequately cover heritage issues. And so what the court said is that, while law and policy, aren't prescriptive, as you've just said, Bramshill, about the way in which the assessment is to be carried out. Nevertheless, the decision makers got to have sufficient information to be able to carry out the assessment, and that wasn't the case here. And so the claimant was successful on that ground.
And I think one of the key facts for me in the case is that the Secretary of State's decision did go against the examining authorities panel, as you say. The Highways England had in their evidence supporting the application, they had identified that there was less than substantial harm to some of the affected assets. The panel had disagreed with that. As I read the case, they found that actually in some cases there was substantial harm, and so they had applied the more stringent policy test that you outlined previously. And on that basis, they'd recommended that the application ought to be refused. When that recommendation came to the Secretary of State, he disagreed and came to the conclusion actually Highways England had been right all along. It was less than substantial harm that had occurred, and applied the more relaxed policy approach that flows from that, and therefore granted the DCO. And I suppose, Howard, this is one of the issues, isn't it, in which the judge found fault with the Secretary of State's approach.
Yes, and this is one of those cases where it's very much in the write-up and the working. It's what I often call to clients, it's the O-level maths point, which is that you only get points and get the answer right if you show the working. And what happened here, as Ian has described, is that there was an assessment of the impact on the significance of the various heritage assets, and whether the harm in relation to them was substantial or not substantial, and that was all carried out. It will be no surprise that for a project of this sheer scale and importance, vast amounts of work will have been done on this, and it will have been conscientiously done by Highways England and their advisors. This will not have been an underprepared application. It will have had vast documentation accompanying it. That then is presented in the examination. That went through the examination. The examining authority made a series of findings, and because these are matters of expert evidence and opinion, it was entitled to come to a different conclusion to the one that was contained in the application documents. And it found that in relation to some of the assets, there was substantial harm. And it then recorded that in its report to the Secretary of State, which was sent to the Secretary of State. The Secretary of State then has, on receipt of that report, a mere 3 months to take it from receipt to issuing a development consent order, which by any stretch, given the volumes of information available, is going to be a tough thing to do for the officials and even for the Secretary of State, who will receive a chunky report in his red box on some Friday night just before he needs to make a decision. Where the Secretary of State came to was to agree with Highways England, but the problem here is the showing the workings issue, because he agreed with the examining authority in relation to the individual assessments, but then disagreed with the overall conclusion. And there is a break in the logic there, that he had shown that he agreed with the individual assessments, which the examining authority concluded led to substantial harm, and then he disagreed with the overall conclusion as to substantial harm. And that is the problem that the court found. Now, it was argued, of course, that the Secretary of State had all of the information before him. However, the judge went behind that and looked at what was actually available. And he did not have a draft decision letter which actually explained how he had got from the substantial harm conclusions for the individual assets to the not substantial harm conclusion for the overall assessment. There was no briefing from officials, and there was no other way that he could have shown that he had come to that conclusion. And for that reason, the court found that the decision was unsafe. And that is why that first ground was successful against the decision of the Secretary of State.
It's a really important point, isn't it? And the judge sort of begins quite early on in the judgment. He sort of makes the point that he's not there, and it's not the role of the courts to look at the merits of the decision and get involved in what are fundamentally political issues or planning issues. He's there to make sure the decision's been made in a legally robust way. And yes, I suppose the Secretary of State is perfectly entitled to agree with the individual conclusions and of the panel, but then form a different conclusion on the overall balance. But if he's going to do that, it's that good old sort of duty to give reasons effectively coming in, isn't it? If you're going to do that, you need to set out that working out. So I suppose the Secretary of State could conclude that 2 + 2 = 6, whereas the panel thought it equaled 4. He's entitled to do that as long as he explains why he's arrived at that different answer, isn't he? It's a key point for decision makers that comes out of the case.
Exactly, and this is like a science experiment. It has to be capable of being replicated by a third party who were to look at the information that was before the decision maker and say, yes, I can see how you reached that conclusion. And in fact, the judge said that if it had been argued that the information was there in some other way, he would have found that the reasoning was inadequate if it had been argued differently. So there's a real issue about how things are written up. How does that affect applicants? Because it's important to think about the practical consequences of this. It's important to make sure that if a conclusion is being reached, you can show in your submission, which hopefully will be recorded by an examining authority, a local planning authority, or an inspector and inquiry, how you follow through. So that's recorded and available to the decision maker, and that assists with protection for the decision.
So moving on to one of the areas where the claimant was less successful, so I think there were across the claimant's grounds, there were 10 issues in the case, and actually the claimant was unsuccessful on 8 of them, which as anyone ever involved knows, it's sort of even more galling when you lose having won most of the points, but claimants only ever have to succeed on 1 point, I suppose. But one of the areas where they were less successful, I think, was nonetheless interesting, and that was the claim that they made that the Secretary of State had wrongly double counted the heritage benefit in his analysis. What did you think on that, Ian? And particularly, what did the claimant mean when he was suggesting when they were suggesting that the Secretary of State was double counting?
Yeah, so this is the double counting point. I mean, I think just on counting, just before we sort of move on, I should probably just record. I'm not sure that concluding that 2 + 2 = 6 would be a sort of within the reasonable planning judgment of the Secretary of State. But yeah, so this was
rationality point there, isn't there?
this was ground 3 of the challenge. And what the claimant effectively was arguing in this case is that the Secretary of State sort of took into account the heritage benefits twice. So once as part of the sort of overall balancing exercise, and then again to sort of reduce the overall level of heritage harm. So when earlier on we were talking about the MPPF tests and how it obviously made reference to effectively the same tests that appear in the national policy statement. What the claimant was saying is that when deciding whether the degree of, or making a decision on the degree of harm to the relevant heritage asset, so whether it was substantial or less than substantial. What the Secretary of State had done is to carry out a sort of internal balance, as they called it. So he'd weighed the benefits against the harms, and then he'd come to an overall conclusion on that element. And then he'd weighed the heritage benefits again at the end as a sort of a public benefit. So when at the end of that test, he'd sort of carried out the overall balance, he'd included the same benefits again. And the claimant sort of said that was impermissible and described it as double counting. And I mean, this section of the judgment I found quite interesting in a sort of, geeky planning lawyer way, because it is quite an interesting consideration by the judge of how a decision maker should sort of go about approaching these issues. And the court looked at the case of Bramshill that we've discussed a couple of times already, and what the judge sort of effectively concluded were two things. So the first point is that when we're assessing an individual asset, it's acceptable to weigh the beneficial and the adverse impacts of the scheme on that asset when coming to a judgment on significance. But then when the scheme would cause harm to one asset but benefit another, although that doesn't reduce the harm to the first asset, the benefit can be weighed in the overall balance. So they were the two things that to come out of the Brownsville case, and sort of applying that to this particular case. What the court said is, there's a difference between deciding which test should apply. So they called it the fork in the road test. So deciding whether there is substantial harm or less than substantial harm. There's a difference between doing that and then to carry out the overall balance. So weighing up whether the public benefits or the substantial public benefits outweigh the harm. And really what the Secretary of State's not doing is not counting the heritage benefits twice. He's just considering them in different ways for different purposes. And that was found to be completely acceptable and regular, and the way that the decision should be carried out. And the judge sort of highlighted a number of other instances in the planning system where this sort of thing happens, and effectively commented that this was just a sort of a facet of how policies often work. So the example given was green belt policy, for example, under the National Planning Policy Framework, and also the paragraph 11D tilted balance in the NPPF. So the judge dismissed that ground, but it's as I say, it's an interesting part of the judgment. I recommend if you don't read anything else from the judgment, that bit is interesting for anyone who sort of works in planning or who's interested in that sort of decision making process.
It comes up a lot, and I have to admit, as I was reading the judgment, I had to read it a couple of times to come to the conclusion that I could see where the judge was coming from, because it automatically you do think there's something unfair in saying, well, you've used the benefits to conclude that there's the level of harm is less, and then you're going to use the benefits again to decide that those already reduced harms are outweighed. There is something sort of automatically you react against that, but there is I thought there is a logic to what the judge is saying, and it is a logic that actually has quite wide-ranging impacts, because I think it goes beyond just heritage. I think this is a point that actually will impact on a lot of decision making, and indeed I think he and the judge actually identified that. He used a few examples outside of heritage, didn't he, where he also found that double counting was not objectionable, I think were the words he used.
Yeah, exactly. So the point about green belt policy was the one that sort of stuck out to me, and the judge effectively was just saying, that policy tests quite often require the same thing to be considered in different contexts and for sort of different purposes. So I mean, it is something I think that will come up again, because I mean, I think when we were talking about this earlier on, I mean, both of us have come across cases where there've been sort of accusations of double counting in a heritage context. So I think it's a real key sort of takeaway point for people from the case.
The example I thought was interesting the judge gave was around one of my favorites, NPPF 11D, and the balance and the presumption in favor of sustainable development. And I think the point the judge was making there was that it is not objectionable when you're looking at the weight to attach to a policy that's out of date, that when you're carrying out that balancing exercise in 11D, you take account of the fact that the weight to attach to an out of date policy should be reduced because it's out of date. So you've effectively already used the out of date character of the policy to affect the outcome of the presumption. That then obviously filters through to section 38.6 and it becomes a material consideration in planning balance. So you then have that 11D conclusion as a material consideration on one hand, and you then weigh that against the conflict with the plan. And in carrying out that section 38.6 balance, you come back to the plan, and again, you may, as a decision maker, decide to reduce the weight to attach to the conflict with the plan because the policies of the plan are out of date. So you've got that the out of date character of the policy sitting on both sides of the equation, suppressing the weight to the plan whilst also increasing the weight to the material considerations. And I thought it was interesting there to say the judge was entirely comfortable with that and was saying that is proper, that is not objectionable. It is, what you're doing is not double counting, but as you say, you are using the same factor at different stages in a policy and decision making process. Yeah. Howard, in terms of DCO and the NSIP regime, does that resonate? Does that issue come up elsewhere in the same way as it does across the MPPF, for example?
It is very similar, and it's always just one of those things one has to watch out for, as I say, in the showing the working. And the critical element is to record this in application documents. There's no statutory requirement for a planning statement, rather like in the general planning system, to accompany an application for a development consent order, but it's exactly the sort of thing that has to be set out in application documents. And so for that reason, you'll very often have a case for the scheme document which grapples with this type of consideration. And it is a thing which examining authorities bring up frequently in their questioning of applicants during the examination process. And a lot of midnight oil is burned in addressing these questions.
I'm conscious of time, so I'm going to move us on, because there was the other issue on which the claim succeeded was failure to consider the merits of alternative schemes. And I think, Howard, it comes up very rarely in terms of general planning, but it comes up all the time in the context of the NSIP regime, doesn't it? So why is consideration of alternatives so important with a DCO application?
So this was very much towards the end. In fact, the last ground that's covered in the judgment. You've got to remember that Mr. Justice Holgate is a planning judge, a planning lawyer beforehand, of very, very high quality and reputation, and has an amazing brain and capacity for work. He has grappled with this immensely complex set of facts, and the party to the case will have been sitting in court, or metaphorically sitting in court, listening to the end of the judgment, thinking, well, at least we've only got the one point that's been found against us. And then he comes to this final point, which is about alternatives. For an NSIP, particularly a linear scheme, this is very, very important because they affect so many people's homes and lives, depending upon where they're sited and where they're rooted. And that means that in preparing an application for a DCO, it will frequently go through a number of iterations of public consultations as you refine the alternatives that are available until you get to the statutory consultation on the application scheme. And that's typical for a DCO, particularly for a linear scheme. And that means that the case law in relation to alternatives and the statute law in relation to alternatives are very important in the DCO regime. In this particular case, we see partly what has happened is a consequence of the way we traditionally write up alternatives judgments in DCO decision-making, DCO applications. And the National Policy Statement requires there to be an assessment of alternatives, as you very well might expect. And there has to be an options appraisal, it says, and then one has to comply with the legal requirements for alternatives assessment. And we typically find those alternatives assessment requirements for projects in things like the EIA regulations, which require us to report on alternatives, habitats regulations assessment, which require us to consider alternatives if there's a residual effect upon the significant assets of an international site, in the Water Framework Directive, and so on. Now, in this case, the court reminded us that there is also a common law duty to consider alternatives, and that actually comes from the general planning system. And that is what was in play here, and it looks back to some relatively old cases that have been considered over the years, and how they played into the way that heritage was considered, because heritage spoke again in the question of alternatives.
So what was it that the Secretary of State got wrong in this case, Howard? Where did it all fall apart on this issue?
Right. So the way that alternatives are typically written up in an environmental statement or the documents which accompany any type of application is that you have an alternatives chapter, which is at the beginning of the environmental statement or a submission document, for instance, in relation to compulsory purchase. And there you describe the exercise that you have gone through. Have to remember here that Highways England had perfectly properly concluded that there was less than substantial harm to the World Heritage Site and all of the assets within it. And so therefore it did not see a particular need to consider alternatives. It then went into application and into the DCO application, and the examining authority started to look at the question of the impacts on the various assets. Once it had done that, it found itself in the position of the paragraph 5.131 and 5.133 tests that we've discussed earlier. And once you are there, the test under 5.133, when we've identified, as the examining authority did, that there was going to be substantial harm to these critical assets, in those circumstances, the second limit of the test is that the impact is outweighed because it is necessary to deliver substantial benefits. There are two limbs to that test. The first is necessity, and the second is substantial benefits. So, bearing in mind the Secretary of State's conclusions in relation to substantial benefits and his conclusions in relation to substantial harm, we come to this question of necessity. And that, the court said, means that the decision maker and those advising have to direct their mind to whether it is necessary to cause the impacts to the critical, valuable assets. Now, in the Stonehenge case, Highways England had discounted two very expensive, but nevertheless engineering feasible in engineering terms, alternatives, both of which would have extended the tunnel beneath Stonehenge further to the west, thereby, it was said, reducing the impact on certain assets. Highways England's position was that these were too expensive and that in any case, they would have very minimal effect upon the in reducing the impact on the assets. There was no view from historic England in relation to whether that was the case, and the examining authority did not direct its mind, having concluded as to whether there was a substantial harm or not, did not direct its mind as to whether those alternatives would have improved the situation. Now, the historic case law says that the fact that there might be a better alternative is not really important in decision making if a project is acceptable, a development is acceptable. But, and this comes from a case called Trusthouse Forte versus Secretary of State for the Environment, it's a 1987 case. But if there is a substantial planning objection to the case, then that alternatives question does come into play. And because of that, in these circumstances, the question of the alternatives was in play. Again, this wasn't fully investigated by the examining authority, wasn't before the Secretary of State, and therefore the decision was flawed. And that is where the thing went awry here.
And it is, isn't it? It was interesting that whilst it's something that comes up more in NSIPs and DCOs than in normal planning, it was normal planning cases that the judge was considering. And I think that there is a direct parallel there. If it seems to me, if a proposal is concluded to have substantial harm, and you're then applying a very high test to justify an approval under the MPPF in that process, actually it does seem to me it would be relevant and it would be a material consideration to look at whether that those benefits you're placing weight on can only be secured in that particular way that causes that substantial harm. If not, if those benefits could be secured by lots of other routes that didn't have that adverse impact on heritage that we have to place great weight on because of the statutory protections, that would be a material consideration, and you would then get into that issue of alternatives, I think, even if this had been under the 1990 Act.
Yes, that's absolutely right. It is a common law point, and it's important to realise that in the planning field and also in the compulsory acquisition field, there are common law tests in relation to alternatives, not just the statutory test that we're all very, very familiar with. And so you do have to have regard to this. You do have to ask yourselves a what if question, a counterfactual question, and you have to have sometimes difficult conversations with clients. And it's worth bearing in mind that the two alternatives that Highways England had identified that would affect the western portal of the Stonehenge tunnel were valued in hundreds of millions of pounds in terms of the additional cost. These were not marginal differences easily resolved. These were things which would have been expensive to deliver and have to be considered very, very carefully.
So bringing all this to a conclusion, what I suppose a question for both of you really, what is the practical takeaway that those submitting planning applications or promoting DCOs needs to take away from the case? Ian, perhaps I could come to you first.
Yeah, thanks, Trevor. So, I mean, there are a number, I think, aren't there? I mean, I think obviously the main takeaway is the Bramshill point that we covered earlier on. So, you know, if you're in a situation where, you know, your development is affecting a number of heritage assets, each of those has to be assessed individually. So you have to make sure that you do an assessment that comes to a conclusion in respect of each of them. The way that that should be carried out is sort of flexible to a certain degree. So there is no prescribed way that you have to carry that out, but it needs to be clear that that assessment has been carried out. I suppose, you know, in terms of practice for decision makers, I mean, you know, in this sort of particular case, obviously the Secretary of State was the ultimate decision maker and was considering a report from the examining authority. And, you know, because the Secretary of State wanted to or decided to disagree with the examining authority on certain points, it was important that the right information was in front of him when he was making that decision. So I suppose for decision makers, you know, it shows the importance, I mean, generally, but in heritage terms in particular, of making sure that that information that I was just talking about is available to the decision maker, so that if they're going to make those sort of judgments, it's been made on a sound basis with sufficient information in front of them to do that.
Howard, what about you?
I think the write-up is critical. I think it's a question of presentation for applicants, and it's a question of how, if you're a practitioner in government or local government, it's really important to look at the way things are written up. I think there is a really solid reminder about the importance of alternatives, and as Ian says, it's important to realise that whilst the courts have not been prescriptive about how assessments are carried out, there is a premium on ensuring it is done thoroughly. And whilst the National Policy Statement does talk about proportionate assessment depending on the value of the assets, there's no question that one has to make sure it is thorough and properly addresses all of the various aspects of the scheme and its impact on critical heritage assets.
And is then documented. That's the key, isn't it? You've got to do
absolutely.
It. Absolutely, you've got to show that working out, as you said. I think the other one for me is, and this was a Secretary of State decision, and therefore the Highways England as applicant didn't have the luxury. But if it were a planning application, you do sometimes get an opportunity to see the committee report in advance. And I think that's the other takeaway for me, is if you have that opportunity, there is always value in sense checking the decision-making process, because you're left feeling a lot of sympathy, I think, for Highways England. There's no criticism of them or anything they did in this process. It is the approach of the decision maker and the failure to show his working out, rather than their failure to properly evidence the scheme that's their undoing. So I think when you have that opportunity as an applicant to influence the way a committee report is written, then it's an opportunity that should always be grasped in order to avoid unpleasantness like this after the event.
And I think if you are the decision maker, Trevor, to be honest, I think it is often helpful in sort of significant decisions or decisions that might be subject to challenge, for example, to do that, to share a draft with the applicant, because I mean it's easy, I think, to lose sight if you're the decision maker. Your own reasoning process. It's easy to lose sight of how that should be documented, obviously to make the decision sort of robust against legal challenge. So I think it probably works both ways, that point, doesn't it?
I entirely agree. I think particularly with the local authority, quite often the local authority is stretched in terms of its resources. An applicant will often have a plethora of experts supporting the application, and a local authority, why would you not use that experience and expertise that's available to make sure that you are properly summarizing the decision-making process and ticking all those boxes? I completely agree. Well, conscious of time, so let's end this part of the session there. Thank you to both Ian and Howard for that discussion. We could clearly go on all day, and probably will when we walk out of these meeting rooms and see each other in the flesh in a few minutes' time. But if I could just very briefly before we close, just turn to other news. There isn't a huge amount, having had the summer break. Both the court and indeed Parliament and the government have been putting their feet up, sunning themselves somewhere, I'm sure. So not a huge amount to report, but a couple of legislative changes that were introduced at the end of the session before Parliament rose for its break, that I thought it was just worth flagging up very briefly. The first of those is the second set of amendments of the year to the GPDO in England. Those changes came into force on the 1st of August, so they have already taken effect. Nothing of any great significance in there. Broadly, the changes are tidying up references to use classes and updating the PD rights to reflect those recent changes to the use classes order, particularly the introduction of use class E, and also making some changes which we've discussed on earlier episodes of Outline, to reflect the introduction of the new requirements for fire safety issues to be considered and consulted on in the context of taller buildings. There are some other minor tidying up amendments in there, but as I say, nothing that will be earth-shattering, I'm sure. The other legislative change which has come out, which will be of interest to anyone that is dealing with the dark art of compulsory purchase compensation. Home loss payments are being increased. Both the maximum and the minimum home loss payments are being increased. Those increases will apply to any displacement that occurs on or after the 1st of October this year. So if you're dealing with compensation claims and those compensation claims include an element of home loss payment, then have an eye on those regulations and the changes, which may or may not impact you depending on whether the displacement happens before the end of this month or not. That was it. No doubt now Parliament is back. We may start to see some progress again on the Environment Bill. We may even see a planning bill, and no doubt yet more changes to permitted development rights, use classes, SIL, and all the other stuff that Parliament is addicted to changing on at least an annual basis. So we'll keep you up to date with all of that. We've mentioned a number of cases during the session today. We will make sure that we include references, the full references to those cases, in the email that will come out to all viewers of the live broadcast when we send through the link to the recording. we will post the recording over the next few days on the YouTube channel, and we'll also make sure that the references to the cases are in the blurb alongside the recording on YouTube. But for now, if I can just thank again Howard and Ian for that discussion today, and if I can also thank you for joining, and we'll look forward to you joining us again for the outline session next month. Thank you and goodbye.